So we have some major news in the challenge against the ATF's pistol brace rule. The Trump DOJ just agreed to drop the Fifth Circuit appeal in the mock lawsuit, meaning that the prior decision striking down the pistol brace rule nationwide will now stand, and the Fifth Circuit just issued their mandate on this issue. So let's break down what is happening. Now, before we jump into this video, I want to thank the sponsor of this video, which is Attorneys on Retainer. When it comes to protecting yourself after a self-defense incident, AOR is in a league of their own. AOR is an actual law firm, so they can help you in self-defense situations and even in states that maybe other companies would not. Recently, AOR was able to protect one of their members in the state of New York, which is unique because AOR can operate in New York when other companies maybe couldn't. So again, check out my link down below. And if you sign up using my code ARMEDSCHOLAR, you can get $50 off of your individual sign-up plan or $25 off of a family plan. So as I mentioned in the intro, in this video, we need to talk about some of the important news in the battle against the ATF and their current restrictions on all brace pistols, and the ATF and the prior Biden administration trying to treat them as SBRs. The Trump DOJ recently stipulated to the Fifth Circuit that they have agreed with the plaintiffs in this case to drop the active appeal on the whole pistol brace issue. You may recall that currently there is a nationwide vacatur of the pistol brace rule and multiple preliminary injunctions which are protecting various 2A organizations and their members. The nationwide vacatur of the pistol brace rule was recently appealed to the Fifth Circuit by the Biden administration. However, once the new administration got control, the Trump DOJ has now decided to drop the challenge at the Fifth Circuit level. The recent notice submitted by the Trump DOJ and the plaintiffs in this case to the Fifth Circuit state that, pursuant to the Federal Rule of Appellate Procedure 42B1, the parties hereby stipulate to the dismissal of this appeal, with all parties to bear their own costs. Plaintiffs retain the right to seek attorney's fees in the district court, including attorney's fees incurred by the appeal. So we need to talk about what this means, what happens now going forward in the recent order that was just issued by the Fifth Circuit, acknowledging this, dismissing the case, sending it back down to the district court, and issuing their final mandate. Now, you may recall that the ATF recently suffered a lot of losses in a variety of these pistol brace cases. Not only did they have multiple preliminary injunctions issued against them, but also recently Judge Reed O'Connor in a federal district court in Texas issued a final merits ruling in the mock lawsuit, and that struck down the pistol brace rule entirely on the final merits. In this ruling, Judge O'Connor stated that at the conclusion of the majority's careful analysis, they held that the final rule is properly characterized as a legislative rule, and it's relatively straightforward that the final rule was not a logical outgrowth of the proposed rule. Therefore, the final rule must be set aside as unlawful. Now, that decision by Judge O'Connor was huge because it was a final merits ruling and it struck down the pistol brace rule entirely based on a violation of the APA. In response, the then Biden ATF decided to appeal to the Fifth Circuit, and there was also a temporary abeyance that was issued in this case when Trump won the presidency and the Trump DOJ got control. So there was a temporary period of time where this case was on hold, and then there was also some deadlines for them to respond, which we never saw. And then eventually we also saw a notice from the Fifth Circuit that they were going to move this case along for an appeal and oral arguments. But then we got notice from both parties to the Fifth Circuit that the Trump DOJ has decided to pull the appeal and concede this case. So that's significant, and it's a big win for the Second Amendment movement. But there's also a lot of moving parts with this where maybe this is a temporary win, but also some things are still lingering out there that could potentially be bad when you look at the future and maybe a new administration. So first and foremost, this notice only indicates that they are dropping this appeal in the Fifth Circuit. In practice, what will now happen is Judge O'Connor will issue his new ruling. He will finalize it. And also what we just saw is we were waiting for the Fifth Circuit to actually issue their mandate and acknowledge that, yes, they're going to drop this appeal and recognize that the parties have agreed to dismiss this appeal. We just got that mandate, and the Fifth Circuit order states that under Federal Rules of Appellate Procedure 42B, the appeal is dismissed as of July 25th, 2025, pursuant to the stipulation of the parties. So the Fifth Circuit has acknowledged that the parties have decided to stipulate that the appeal is dismissed. The Fifth Circuit has issued their mandate, and now this will head back down to Judge O'Connor. Now, there are also other lawsuits still out there, and there's more cases than just the mock challenge. You have the multiple cases in the Fifth Circuit in that jurisdiction, which include the GOA case, the NAGR case, the Brito challenge, and other lawsuits in other circuit courts. So a lot of those were also still at a preliminary injunction level. They were dealing with those types of issues. and a lot of those were put on hold behind mock. So everybody was waiting to see what would happen at the Fifth Circuit level with this appeal at mock. And now that the mandate is issued and this is heading back to the lower court, I assume that all of these district court challenges that were on hold will now kind of be revitalized, be reactivated. In a lot of those cases, what I assume will also be dismissed based on the Trump DOJ and the Trump ATF saying that they are no longer going to challenge this issue. In essence, the pistol brace rule put in place by the Biden ATF will now be struck down completely. Now, there are a couple other wrinkles with this that I want to point out. First, like we saw with the FRT settlement that happened in the Fifth Circuit, there's also a chance that maybe anti-gun groups like Giffords or Everytown may try to pick up the torch and go after these companies that sell braces, maybe go after SB Tactical and all those, other companies. And despite the settlement, with the FRT case, you saw a lot of those anti-gun groups still decided to try to sue those companies. So that could also happen here when it comes to pistol braces, but that would be kind of litigation against those specific companies. Another thing that I want to note is kind of the long game implications of this decision and the decision to not allow this to move forward to the appeal and the oral arguments. To agree to kind of drop this appeal at the Fifth Circuit level does have some implications, specifically because of what Judge O'Connor ruled on prior. By agreeing with the Trump DOJ to drop the appeal, you get an immediate win, and you kind of get that immediate end of the pistol brace rule as it's currently configured, but you also lose the opportunity to get a larger, more impactful final merits win from that Court of Appeals. Remember that the mock case was only ruled on by that district court judge, Judge O'Connor, and it was only based on the APA, also known as the Administrative Procedures Act. If another anti-gun administration comes into office and they decide to take another crack at this whole pistol brace issue, the only precedent that you actually have is some district court rulings in the mock case, and then also some rulings from various circuit courts when they were on preliminary injunction reviews, so not final merits reviews. Now, if another administration tries to put in place another pistol brace rule, it could look a little bit different, but they could also try to use the same exact type of rule, but just follow the correct procedures. Remember that Judge O'Connor only struck down the ATF pistol brace rule based on a fact that the ATF and the Biden ATF violated the APA's procedural requirements as far as it did not follow the logical outgrowth test. The main issue Judge O'Connor had with the pistol brace rule was not that it violated the Second Amendment or anything like that. The big sticking point was that the proposed rule had the worksheet 4999 and a whole point system that was later just completely eliminated, scrapped, and was not included in the final rule. So in essence, another administration that is anti-gun could take another crack at putting in place a pistol brace rule in the same form, but just simply following the APA's procedures. That's why I'm saying this is an immediate win, but also kind of leaves the door open a little bit for a later anti-gun administration to kind of use the same type of rule and just follow the procedures and try to maybe take another attack on pistol braces in the future. But for now, that is what the Trump DOJ and the plaintiffs decided to do. They decided to kind of settle this case, remove the appeal, and let the Judge O'Connor nationwide vacature of the rule take effect and, strike down the rule nationwide. I would also assume that there's going to have to be some sort of settlement agreement or some sort of a decision on maybe people who decided to register the braced pistols as SBRs. Since the rule is going to be vacated, I would assume that there's going to have to be some sort of decision on what to do with those individuals. So this is a win. It's a win against the critical pistol brace issue, getting rid of that, allowing Judge O'Connor's nationwide vacature to go into effect. Now that the mandate has issued by the Fifth Circuit, this is going to be back in the hands of Judge O'Connor, and I would assume he's just going to finalize his nationwide vacature of the case. After that, I would assume that we're going to see all the other pistol brace lawsuits get resolved. So we're going to get more information on that as stuff unravels, and you would see a lot of those other cases finally get resolved that were sitting behind the mock challenge. So good win. The final mandate has issued by the Fifth Circuit. This is going to go down to Judge O'Connor, and then he's going to issue his final decision and mandate on the case saying that, yes, the pistol brace rule is vacated nationwide as a violation of the APA. So as we get more information, as this unravels more, I will let you guys know. If you guys like this video and you would like to support the channel, one of the best ways to do that is to simply subscribe to the channel. That, of course, helps the channel to grow. You can also check out the free legal guide that I have available for you guys. I will leave a link to it down below where you can sign up. All you have to do is put in your email, and then you get that free PDF. It gets sent to your email, and then if you don't see that, check your spam folder because sometimes it ends up in spam. You can also check out my website where we have some deals and merch and all that as well. That's another way you can support the channel. But as always, thank you guys so much for all of your support. And never forget, this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.